everyone, and welcome to the daily newspaper analysis brought to you by LawSikho. I hope that you're all doing fit, fine, and amazing. So we have an article from the Indian Express that talks about the hijab case. Of course, we have discussed it several times, but we will be talking about that where the judges at Supreme Court have differed on this particular Karnataka High Court judgment. Secondly, we'll be covering the news update, and thirdly, we'll be having the legal news for the day. So the Supreme Court has delivered a split verdict in the Karnataka Hijab case. Now, with the two-judge bench divided in its view, the matter was directed to be placed before a Chief Justice of India, that is UU Lalit, for appropriate directions. Now, as we know that very recently, there was a great hustle in the state of Karnataka regarding the right to wear hijab, specifically by school-going girls. And the Karnataka High Court had given a verdict that right to wear hijab was not an essential practice, and that they may be not allowed, or maybe they can be asked to take off the hijab. Now, when this particular thing was taken to the Supreme Court, the Supreme Court has also had a split verdict on this issue. So we'll discuss them accordingly. Firstly, let's see that what have the judges or the justices in the Supreme Court they have to say against the High Court verdict of Karnataka. So Justice Sudhanshu Dhulia quashes the February 5 Karnataka order, which bans the clothes that disturb equality, integrity, and public order in schools and colleges. Please consider that this thing that we can see over here in the inverted commas is the thing that was quoted by the Karnataka High Court with respect to, or with in regard to the hijab. So they said, the Karnataka High Court had said that the hijab would disturb equality, integrity, and public order in the schools and colleges. And Justice Sudhanshu Dhulia of Supreme Court has stood against this particular verdict. So he says that the concept of essential religious practices is not the issue, and it is ultimately a matter of choice, nothing more and nothing less. So he said that we do not even need to consider whether it is an essential practice or not. Simply should be a matter of choice, should be a matter of privacy. And he says that asking a pre-university girl to take off hijab at school gate is an invasion of her privacy, which is very much a fundamental right under Article 21 of the Indian Constitution. So echoing petitioner's concerns that he says education of girls on his mind, and a girl child for whom it is still not easy to reach her school gate, the question is whether we are making the life of a girl any better or not. So if at all we are saying this, and there are girls who come from a lot of orthodox families, from very families that are not already very supportive of education, and if now they would not even be allowed to wear hijab, which might be a very, very important practice when it comes to their religious being in their personal life spheres. So it might definitely hinder several girls to even attend schools and colleges. Now let's see that what arguments do we have in favor of the High Court verdict that back or that support the High Court verdict. So Justice Hemant Gupta dismisses appeals, says he has framed 11 questions and the answers to those are against the appellants. Now these include the respective scope and interplay of right to equality, freedom of expression, privacy and dignity, and right to religious practices under Article 25 and others we all know. Enforcement of uniforms does not violate right to freedom of expression, he says. Rather, it reinforces right to equality. So this is definitely seen through other lens that we can see here, that if at all we think that, we will be able to exercise our right to freedom of expression or right to freedom of religion only if we are enforcing the uniforms. That is not the case. Rather, it says that if we do not, it also reinforces right to equality. So is wearing hijab an essential religious practice? And can the students seek to wear it to school as a matter of right, he asks. So definitely these are the questions that need to be thought upon. Now here on the next slide, we have the timeline for the entire hijab thing. So if you are intrigued enough, you can definitely go through it, how it started on June 1st, 2021, and what update till we have till October 13th, 2022. So you can go through the same. Now let's see what do we have for news updates today. Firstly, NPCI, that is the National Payments Corporation of India, collaborates with Worldline to support UPI, that is the Unified Payments Interface, RuPay payments in Europe. So French multinational payment services firm Worldline has collaborated with the NPCI International Payments Limited, that is NIPL, the global arm of the National Payments Corporation of India, to support Indian digital payment modes in Europe as well. So Worldline, as part of the tie-up, will enable the merchants' point of sale systems in European markets to accept payments from Unified Payments Interface and instant real-time payment system, as well as RuPay, NPCI's proprietary card payment network solution. So with this, when we travel to Europe, so we will be able to use our Google Pay, Paytm, or whatever the UPI system that we use directly. And basically, the UPIs that we have that use the Unified Payment Interface, we all have our UPI IDs. I hope you understand this. So they will be functional in the countries they are outside India as well, which will be definitely a very good step for very easy and smooth transactions. On this note, I have a question for you all. Can you tell me that which other country, here's a hint for you all, it is a neighboring country of India, also has this system already available, wherein the NPCI and UPI have started functioning, and they're already in talks with this, and that these payments can be made online over there as well. So if you know the name of this country, let me know in the comment section below. Secondly, Odisha Chief Minister Naveen Patnaik launches Football for All. So Odisha Chief Minister Naveen Patnaik has launched Football for All in the state to take the culture of football to the grassroots. The program has been initiated by FIFA in Odisha in partnership with the Kalinga Institute of Industrial Technology and Kalinga Institute of Social Sciences. Thirdly, the center approves PM DevINE Scheme. Basically, the Union Cabinet approved a rupees 6,600 crore scheme in a bid to fund infrastructure projects in the northeastern states. The scheme, a Prime Minister Development Initiative for Northeastern Region, that is abbreviated as PM DevINE, will be applicable for the next 4 years of the 15th Finance Commission from 2022 to 23 to 25 to 26 as per government data. The new scheme will get 100% central funding and will be implemented by the Ministry of Development of Northeastern Region, that is in short also known as donor. The infrastructure projects will be funded in the line with the priorities laid down under the PM Gati Shakti program. Fourthly, India ranks 123 on Inequality Index, moves up by 6 places. So according to the recent commitment to reducing Inequality Index to 2022, India has ranked 123 out of 161 countries in reducing inequality. India's ranking has risen by 6 places, which shows improvement. However, India still remains amongst the worst performers in terms of overall spending in the healthcare sector. Let's see what do we have for legal updates today. Firstly, third gender candidates entitled to special reservation, Madras High Court has said so. So the Madras High Court has directed the State Health and Family Welfare Department and Directorate of Medical Education to provide special reservation to the third gender or transgender in the admissions of post-basic nursing course. And this was held in the case of Tamilselvi versus the Secretary of Government and others. Secondly, stockbrokers should obtain a certificate of registration from Sebi for each of the stock exchange where he operates, says the Supreme Court. So the Supreme Court has held that a stockbroker should obtain a certificate of registration from Sebi for each of the stock exchange where he operates. This was held in the case of Securities and Exchange Board of India, that is Sebi, versus National Stock Exchange Members Association. This was all for today. We hope you liked the session. Thank you so much for staying tuned with LawSikho. And if you wish to download the PDF of today's slides, you can join our Telegram channel. The link is there in the description box below, or you can also scan this QR code that you can see on your screens right now. Thank you so much.